My intention is to argue the second interrogation video, which is 95% Detectives Florio and Tabor and 5% Tyrone Johnson saying the same thing he said all along.
Sometimes the biggest question in a trial isn't the evidence that shows, it's how the jury hears it. In the Florida death penalty case now, before the state Supreme Court, defense attorneys are arguing that the key interrogation video shown at trial was almost entirely detectives talking, not the defendant. Their claim is simple. When a video is 95% investigator and only 5% suspect, does it help the jury to understand the facts, or does it quietly reinforce the state's theory of the case? Here's the exchange that caught the court's attention.
I also intend to argue the brother that went rogue and then was prevented from recanting by the state's heavy-handed and coercive threat of a perjury prosecution. If time permits, which I doubt, but if time permits, I may argue the trial court's legal error and misuse of two important mitigating factors to denigrate one another. In this case, the prosecutor set the table at trial for the second interrogation video in his opening statement to the jury. It tells them, "You will hear what Johnson said happened. It all happened in a bedroom, but you will find he's not a very reliable narrator." Today, tells the jury, Detective Florio and Detective Tabor gave him every opportunity to explain what happened, and he says, no, it all happened in the master bedroom. However, the prosecutor tells the jury, foreshadowing what they will later hear from Detectives Florio and Tabor on the second videotape. Opening argument. The evidence doesn't lie, ladies and gentlemen. Individual can say whatever he wants to say, but the evidence doesn't lie. Moments later, for still more emphasis, the evidence doesn't lie, ladies and gentlemen. And then when the second video played...
Could you quote the prosecutor, right?
I'm quoting the prosecutor talking to the jury.
Okay. But on this issue, it's really about what's in the interrogation. Yeah. What's the worst thing that the officers said from your perspective? The most harmful thing and the most inappropriate thing that the officers said in the interrogation.
Okay, I don't think the officers said anything inappropriate in the interrogation. As my opponent points out, this is standard operating procedure for a confession, for an interrogation. The problem wasn't what the officer said. The problem was it getting in over defense objection before the jury, when all the jury really heard was the steady drumbeat of what the officer said and what the Mr. Johnson.
What did the officer say that was the basis for that?
Okay, what the officer said that was the basis for this. There's also evidence to show that the young man was more than likely trying to get away from you. It appears that what you were telling me doesn't make sense with the scene. If what you tell me doesn't make sense with the scene, because the thing is this, man, and I've been doing this job a long time, I know that the evidence will never lie to me, but people will try to minimize it, try to make themselves out to be something that's not. I hope it matches your story. What I'm being told right now, it doesn't. Do you want a tragic situation where shit went bad, or do you want Tyrone is manipulating anything, and he murdered his girlfriend, and he chases her 10-year-old son throughout the house, killed him, and dumped his body next to his mother? We need you to tell us what happened in Rye's room. We know something happened in there. How did you get to Rye's room? Tyrone, I'm going to have to disagree with you there. So it's very possible you could have moved from the master bedroom to Rye's room because Rye was scared and he was trying to get away from you. So there's only one explanation for the shell casings and the bullet holes in his room. Now, maybe this is what you are telling me and what I'm more than likely be able to prove are two very different things. Tyrone, I'm not out to get you or anything. I just want you to tell me the truth. And then basically, this is your story and you're sticking to it, right? Okay. What you get back from Tyrone, and this is the 5%. I don't know, sir. I didn't go in Rye's room. Everything happened in the bedroom, and a lot of inaudible. Okay. Again, Justice Kennedy, I am not contending here that officers, I've seen many interrogations just like this, in some cases worse, where they're actually coercive. I mean, if Tyrone Johnson had done what
their statements like, we know you did it. And there's nothing direct like that. They're dance around it, but there's nothing that says, we know you went into the bedroom and murdered it.
I would have to respectfully disagree. I mean,
you think it's the equivalent of that?
I read this as we know you went in the bedroom. The evidence shows us we went in the bedroom.
Well,
What
of course,
this
the
case,
evidence does show that. I mean, they're pretty overwhelming.
yeah, well, I see what you. Overwhelming evidence is not the test here. What I want to get to here is, okay, the prosecutor knew that this would have an impact on the jury. Otherwise, he wouldn't have done it. Now,
But isn't the real impact on the jury the blood under the bed and the bullets?
then why introduce this? Then why introduce the second videotape? I cited, I did a notice of supplemental authority on a 1919 case. It's called State versus Gun, cited again in 1968. Old case, but I think it's still good law when you consider the Deus Julio standard as reaffirmed time and time and time and time and time again, says overwhelming evidence is not the test. The test is, could this have had an impact on the jury's deliberations? Could this have, the prosecutor knew it would have an impact on the jury or he wouldn't have fought so hard to introduce
Your
it.
argument is that what had the impact on the jury, let's be specific. It's not the video. You have to show that what had the inappropriate impact on the jury's deliberation is what the officers said in the video. Isn't it true, though, that the state had every reason to introduce your client's denial as evidence of your client's evasion and state of mind about the murder?
They already introduced that in the first part of the video.
Okay, but that's an argument about the potential cumulative nature of this evidence. It doesn't go to the prejudice of it. All the court needs to do in order for us to sustain its evidentiary decision is not abuse its discretion. And I can imagine a court in its discretion finding that your client's denial was relevant evidence about state of mind and how he's dealing with the evidence that he's confronted with. And therefore, it's not an abuse of discretion. And it isn't about what the law enforcement officers were peppering him with.
Yeah.
I mean, help me understand how this constitutes the egregious case of bolstering law enforcement's story by putting them in a position where they're narrating a thesis, narrating a theory of the crime in the video, which I agree with you, like in the Jackson case, is problematic. Here, I just don't see that you have it unless I'm missing something that I haven't recounted in my question to you.
Well, I think this is a lot like the Jackson case, save for the fact, okay, Judge Sabella, in this case, said, when I saw the Jackson case, it scared me to death. But I learned two things in, death penalty judge school. Wise judge said to us, number one, judge shouldn't get out of his lane and do things he's not authorized to do. But on the other hand, he also told us ain't much can't be cured by a jury instruction. Now, the jury instruction here, if you look at the preamble to the jury instruction, what it's for is it's for when something comes in that is admissible for one purpose, inadmissible for another purpose. Okay, the officer's opinions of guilt or credibility are never admissible for that purpose. But in some cases,
they're not proffering an opinion about guilt. This is an interrogation, and they're confronting him with it. It's not like they were called as expert witnesses.
I said right off, the officers didn't do anything wrong.
Okay.
What's wrong is introducing this unnecessarily and prejudicially before the jury. What this kind of comes down to is it allows the state to it's sort of cross-examination by the officers of a defendant who didn't testify. The state didn't get to do cross-examination. What they did a closing argument that was absolutely foreshadowed by what the officers did here. The officers are telling what you're telling us doesn't match with the scene.
Ultimately, the Supreme Court will decide whether the interrogation video crossed the line or whether it was simply just part of normal process of confronting a suspect with evidence. The justice must now determine whether the recording helped the jury understand the case or whether it may have tilted the playing field before deliberations even began. We'll keep following the court's decision as the case moves forward. Thanks for watching Bench Breakdown.